Welcome to This Explainer. Today we're diving straight into a massive investment scam that absolutely shattered the trust of its victims. But more importantly, we're going to look at exactly how the Philippine Supreme Court brings down the hammer of justice using their newly minted legal framework. We are pulling all our facts today directly from the Supreme Court decision AC number 13757. Think about the immense trust we place in licensed professionals. Lawyers swear a solemn oath to uphold the law, right? To be these pillars of ethical conduct in their communities. So when one of them uses that very prestige to deceive people, it's deeply shocking. This is a fascinating look at what happens when a trusted professional builds an illusion only to betray it, and the rigorous, almost mechanical process the legal system uses to finally hold them accountable.
So here's a quick roadmap for today's explainer. We're going to cover the abundance scam, the bounce checks and ghosting, the Supreme Court's new CPRA framework, how they weighed the offenses, and of course, the final verdict.
All right, let's jump right into part one, the abundance investment scam, and honestly, the sheer audacity of this lawyer-led con.
1 million Philippine pesos. That massive figure is exactly what a victim named Darwin handed over. Imagine being pitched an opportunity where you are guaranteed to see a 100% return in just 3 months. You hand over 1 million pesos, and 90 days later, you get 2 million back. It is the ultimate financial dream, right? And it played perfectly on human hope. But Darwin wasn't the only one completely swept up in this promise. Other victims, named Pauline and Abigail, also poured hundreds of thousands of their hard-earned pesos into this exact same incredible promise, fully believing their financial futures were completely secured.
The hook here was simple but incredibly deadly. The victims were introduced to an entity called Abundance International. But the absolute key selling point, the messenger. It was peddled by a licensed attorney, Adi Virajoy Panig, alongside an associate. This lawyer literally weaponized her prestigious title to build immediate, unquestioning trust. We're not just talking about some shady phone calls. She and her associate held in-person seminars. She met victims in nice hotel lobbies to pitch secondary schemes, creating this whole aura of high-stakes exclusive business. The deception actually went so deep that she even pulled up her own son's bank account to show off the supposed profits generated from abundance. And really, who would doubt a sworn officer of the court showing off her own family's financial success? To lock that trust in permanently, she issued post-dated, pre-signed checks to the victims. It made the whole investment feel completely risk-free. It was an air of absolute, unshakable legitimacy.
Which leads us to part two, the unraveling of that deception, the bounced checks, and the inevitable ghosting.
So in July 2015, the initial post-dated checks were handed out to these eager investors. But as that magical 90-day mark approached, the excuses started rolling in. When it was time to cash them, the lawyer explicitly told the victims, hey, don't deposit the checks just yet. She insisted the massive returns were on their way, but changed the check dates to November. And her excuse for the sudden delay? She claimed that she and her son had contracted dengue fever and were hospitalized. It was the ultimate sympathy play, and it bought her some vital time. But the clock was ticking, and by January 2016, the victims had completely run out of patience. When they finally went to the bank to present all these issued checks, every single one of them was dishonored. And the reason wasn't just insufficient funds. The bank accounts were completely closed. The final nail in the coffin? An official certification from the Securities and Exchange Commission, the SEC. The victims discovered that Abundance wasn't a registered corporation at all. It was not a registered investment house. Furthermore, the lawyer and her associate were not even registered brokers. The entire operation, from the fancy hotel meetings to the bank account screenshots, was a total illusion. The victims were left holding nothing but worthless pieces of paper. And the lawyer, well, she simply stopped answering her phone. They were completely ghosted.
This brings us to a huge pivot point for this explainer. When a lawyer weaponizes their title to run a scam like this, how exactly does the Supreme Court evaluate and penalize them? Because remember, a lawyer is supposed to be a leader in the community, an officer of the court. When they cross this line, it's not just a standard crime, it's a deep betrayal of professional ethics.
Let's get into part three, the new CPRA framework, which is a massive, systematic shift in legal discipline. Our source material lays out a literal 5-step framework that the court now uses, which actually became effective recently in May 2023. It's called the Code of Professional Responsibility and Accountability, or the CPRA. It ensures this logical, foolproof path straight from crime to punishment. First, you classify the act based on its gravity. Is it serious, less serious, or light? Second, you look at the baseline imposable penalty. Third, you check for modifying circumstances, meaning are there things that make the crime better or worse? Fourth, you figure out the manner of imposition. And fifth, if there are multiple offenses, you follow a specific procedure to tally them up. This matters to all of us because it means a lawyer's punishment isn't just some random guess based on the judge's mood. It is calculated, it's fair, and it's completely transparent. It takes the guesswork entirely out of delivering justice.
Moving to part 4, we're going to apply this exact framework directly to the scam.
So under Step 1, we have to look at Canon 2 of the CTRA, which dictates proper conduct. It strictly forbids dishonest and deceitful conduct. The court clearly defines dishonest as a disposition to lie, cheat, defraud, or betray. Deceitful is the proclivity for fraudulent misrepresentation upon someone ignorant of the true facts. By faking an investment house, creating fake acknowledgement documents, lying about hospitalizations, and showing off a fake profitable account, the respondent perfectly met these definitions to the letter.
Let's map her specific actions straight into those CPRA categories. The court found 3 distinct violations here. Action 1, issuing worthless checks. Under the CPRA, this is a serious offense because it violates the bouncing checks law and shows a profound lack of personal honesty. Action 2, misrepresenting the Abundance Investment House. This is also a serious offense due to the extreme deceit involved in presenting a fake entity as real. The base penalty for a serious offense is heavy. We're talking suspension or outright disbarment. Finally, Action 3, when the Integrated Bar of the Philippines, or IBP, tried to contact her about these complaints, she didn't respond because she hadn't updated her address while working at a new government job. Failing to update her records is considered a light offense, which carries a baseline penalty of a fine.
Step 3 is fascinating. The court had to weigh the modifying circumstances. Were there any mitigating factors that could lessen her punishment? They looked at the record and found absolutely zero. There was no remorse shown and certainly no return of the stolen money. But when they looked for aggravating circumstances, things that make the underlying crime even worse, they found one devastating factor. She was a repeat offender. The court actually took judicial notice of a previous case, Kabakangon versus Banagbongayon, where she was suspended for 1 year for breaching a contract and not paying back investments in a remarkably similar venture. This proved a total callousness to the court's disciplinary power and established a clear, undeniable pattern of behavior.
And that brings us to part 5, the final verdict. The hammer falls.
Because the respondent committed multiple offenses, the court applied Section 40 of the CPRA, which requires separate penalties for each distinct act. Here is the math the court carefully calculated. For the worthless checks, compounded heavily by her past behavior, a 2-year suspension. For the deceit and misrepresentation of the investment house, again aggravated by her history, a 4-year suspension. And for ignoring the IBP rules, a 35,000 peso fine. Now, Section 40 has a very specific trigger. If the aggregate, or total, suspension exceeds 5 years, the Supreme Court has the ultimate discretion to bypass suspension entirely and deliver the maximum possible sanction. Well, 2 plus 4 is 6 years. The trigger was pulled. The hammer of justice falls exactly as prescribed by that rigorous new legal framework. The verdict from the en banc Supreme Court is absolute and final. The respondent is found guilty of violating the Code of Professional Responsibility and Accountability. She is officially disbarred. Her name is ordered stricken off the roll of attorneys effective immediately, and she must pay the 35,000 peso fine. She is permanently stripped of the prestigious title she weaponized against innocent, hopeful investors like Darwin, Pauline, and Abigail. You know what I love about this source text? It's how the Supreme Court chose to close their decision. They actually cited a famous quote, yes, the Spider-Man quote, reminding the legal profession that, with great power, there must also come great responsibility. The public places licensed professionals on a pedestal, giving them this inherent, almost automatic trust. When someone uses that power to lie and steal, it tarnishes the entire system. It's a powerful reminder that wraps up this explainer perfectly, but it also leaves us with a really provocative question for our own lives. In our day-to-day dealings, how much do we blindly trust the prestigious titles of the people we do business with? Thank you so much for joining me, and I'll catch you in the next explainer.